Case. Oh. Oh. Hello there. No, because there's only one more case after that. Okay, and then we'll finish up. Yeah. Okay, next case is case 16339, Edward and Lisa Slattery, 30 Mark Drive, Smithtown. Location, south side of Mark Drive, west of Maryland Lane, Smithtown, property zone R21. Request variance to reduce the minimum distance from any lot line from 8 feet to 4 feet for an existing 144 square foot shed. May I have your name, please?
Madam Chair, members of the board, my name is Ed Slattery. I live at 30 Mark Drive, Smithtown, New York, 11787.
Okay. Raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
I sure do.
Okay. Just to make sure you talk into that mic, okay?
I'm here tonight with my wife Lisa to request a variance for a 12 by 12 foot shed, which is in my backyard. We are appealing for a variance to change the minimum setback distance to 8 feet from the neighboring lot line to 4 feet. We originally moved into Smithtown in November of 1996 with our 2 daughters. In 2002, with the approval of the DEC and the Smithtown Building Department, we installed an in-ground pool and received the appropriate COs. That same year, in October of 2002, I built a 12 by 12 shed, and through the ignorance, although the ignorance of the rules is not an excuse, I did not know that a permit was required to build a shed and that a setback requirement of 8 feet from the neighboring property line is also required. However, I did build the shed 4 feet from the northwest property line. Then in 2005, we received a permit to build an extension over our garage. Upon the inspection of the framing of that extension, we were informed by the building department that I needed a permit for the shed I had built in 2002. As part of that project, we also refinished the front of our home and wanted to put a portico over the front entrance. So we began the process of filing the permit for the shed and the portico at the same time. During the process of applying for the permit, I was advised of the need for a variance for the setbacks. With college tuition bills for our daughter's mounting, we decided to shelve the portico project, and the entire process fell off our radar. We are now before you here to rectify the situation. The shed was constructed with high-quality building materials. It is sheathed in texture 1011 and has been stained with a redwood stain to uphold the rustic outdoor look of the surrounding woods. The roof is covered with fiberglass shingles. There is a double-hung exterior door. The trim was painted white to add more finished look. We feel the shed poses no environmental hazard or obstruction. Our property is professionally landscaped, and I believe the shed blends in well with the overall appearance and attractiveness of the backyard. The shed is used for storage of lawn furniture, manual gardening tools, and camping equipment. All gas-powered lawn equipment and electrical tools are stored in our garage. Relocating the shed would be a hardship, as we would need to remove trees, which we would prefer not to do, as we like to limit the wooded buffer. We like the limited wood buffer that remains. Additionally, because of the way it was constructed, the shed would most likely need to be dismantled to move. We thank you for your time and hope you will forgive us and any derelictions on our part in this process. If you have any questions.
Any questions? Okay. Thank you so much.
Thank you.
Is there anyone here that would like to be heard on this application? Come up, please. May I have your name and address, please?
My name is Richard Travis, Travis. I live at 32 Mark Drive, and I'm the neighbors of the Slatterys. And
Raise your right hand, please. You swear to tell the whole truth and nothing but the truth?
I do. I'm in an uncomfortable position of having to weigh in and give my opinion about the shed to this board. I have a picture, some pictures.
All right.
That shows the view of the shed from my perspective. It's a lovely shed, but calling it a shed is really somewhat misleading. It's a rather large structure. It's 12 by 12, but more importantly, it's 12 to 14 feet above grade, and as such, it really looms above our fence, and it's an imposing structure. The structure is 3.5 feet from the fence. However, I'm not sure where the fence is in relation to the property line. And finally, I'm nearing retirement, and I might not be in the house for all that long. And I'm concerned that the way the shed, as big as the shed is, the fact that it looks closer to the property line than it is, it might affect my future ability to sell the house. Thank you very much.
You're welcome. Thank you. Yeah. Do you want to label this? If you, oh, it is labeled on the back.
On the back.
Okay.
I think that's sufficient.
Thank you. Okay. You want-
Madam Chairman, could I just look at the picture that he's submitted, or just?
Okay. All right, I'll entertain a motion to close the hearing.
So moved. Second.
Is there any moving second? All in favor? Aye. Motion carried. What? He didn't want to speak. No, he said no. Yeah. Can I have, see, he wants to see this. Is there going to be a problem? Okay. Okay. Okay, next case is case 16200, Vendetta Vita and Mary Appalaro, 149 Walnut Road, Kings Park. Location, north side of Rowan Street, east of St. John's Road, Kings Park, property zone R10. Request a certificate of existing use to maintain a 3-family dwelling in R10 single-family zoning district.
Madam Chairman, members of the board, my name is Vincent DeMarco. I represent the applicant. I have offices at 1038 West Jericho Turnpike, Smithtown, New York. And as usual, I'm giving a memorandum. I have been given a memorandum 1 minute ago. No, less than a minute ago. Is that correct?
Mr. Marco, it was just as a matter of courtesy.
I can't hear you, Gloria. I'm sorry.
It was as a matter of courtesy.
What's the memorandum?
What did you say it was courtesy on your part?
Yes, it was.
Oh, okay. I've always stated to the board, and I apologize, if I would have had this earlier, obviously I could comment on it, but I've just gotten it, and I don't know. I take the time to read it, I guess. I think it's unfair that, you know, I get this memorandum to your board a minute, half a minute before, and I
Mr.
have to comment
Chimarko,
on it.
Allow me to say that this is what you should be presenting to the board this afternoon. This is not news. This is what you should be prepared to present to the board this evening.
You know what? It's my fault. I can't hear you, Gloria, so if you wouldn't mind speaking louder, or I'll come.
What I'm saying is what's in the memo is what you should be prepared to tonight to present to the board. This is not news to you, or it should not be news to you.
Well, it's news to me because you didn't present this memo to me before tonight, and it's a recommendation to the board that I should have an opportunity to deal with these three, I guess, conditions that you're advising the board on.
I don't think they're conditions, Mr. Tramarko. I think you're asking for a certificate of existing use. I think the memo is just to state what the board has to look at, that it's not an area, it's not a variance. There are parts to a certificate of existing use that we have to look at. I think that's all that memo says. It's not a recommendation, it's on that you have to prove that this was a condition of existing use before 1932, then when zoning. I think that's all that's what they
Well,
meant.
first of all, I don't believe I have to prove prior to 1932, because the ordinance, there was, well, here I am doing it, okay. The ordinance was enacted in the first zoning was enacted in 1932, but thereafter, until I believe it was the middle 50s, there was density zoning in the town of Smithtown. Now, we all know, I think we all know, density zoning is entirely different than area zoning, which we have today. For example, R10 zoning, which is where this particular house is now, is 10,000 square feet area. You're required to have 10,000 square feet in order to build a house without a variance. Density zoning is a little different. Density zoning, and I have, which I am going to present tonight, and I might as well do it now, I have copies of the ordinance, the density zoning ordinance from 1932, which continued until the middle 50s, and I believe the density zoning for the area that this house is in required that you could not have more than 22 families to the acre, believe it or not. That's what the ordinance says. So I will present this to the board, even if we say, well, it wasn't, the density zoning in that area was less than that. The most restrictive density zoning at the time was 8 families to the acre. So even if you divide 8 into 4,000, it would be, let's see, 10 would be about 5,000 square feet you would need per family. Now, I guess the town board in its wisdom many years ago felt that this was the type of zoning that made the most sense. In addition, they had side and rear yard requirements, but basically the area was covered in a different fashion. So if you lived in an area that was, I think, E-residence, then you could have up to 22 families to the acre. Was that ever done? I don't know. But certainly, in this situation, even if we look at it at 8 families to the acre, which I don't believe was the case, I think it was 22 because that's the least, the least restrictive zoning in this situation. I believe the last couple of times I presented other evidence with respect to this. I can tell you that, I can't tell you that since 1932, it was, excuse me, there was 3 families there. But my clients tell me that since the early 50s, it was 3 families. My clients also, they purchased the house in, excuse me, in, I think, 1979. Yeah, 1979 or late 78, and it had 3 apartments, 2 upstairs, and I think there's 1 basement apartment. And in those times, well prior to my client purchasing this property, that's what they did, especially in San Remo. San Remo, since there was this very loose type of ordinance, their zoning ordinance, there really wasn't a heck of a lot of control on what went on. And you know, this is what my clients bought in 79. I don't, again, it's not 1932. That's when the ordinance, when any zoning ordinance was enacted in Smithtown. Prior to September 7th, 1932, there was no zoning. You could have done whatever you wanted, wherever you wanted. And then in 32, they enacted the first zoning ordinance. And they enacted it in a little booklet. They didn't have the big zoning ordinance that we have today.
Mhm.
I just want to show it to you right here. This was it. This pamphlet, I guess you could call it a pamphlet, and I copied excerpts out of it.
Use the mic, though, Vinny, use the mic.
Oh. This is the pamphlet. This is the total zoning ordinance in the town of Smithtown in 1932. I don't know if the planning board planning department has a copy of it? We do. Yeah. And this was it. And this is what they went by. And it, you know, was probably a big advancement at the time. So my clients, again, have indicated to me that when they purchased it, it was an existing 3-family. They've paid taxes on it they've paid taxes on it for the past 30-something years, and they would like this board to allow them to continue. I don't know if the basement apartment, I don't know if the building department ever inspected it, whether that was, it meets zoning code or not, but if there is a safety issue with the basement apartment, then I think my clients would look to it and say, we won't maintain that basement apartment anymore. I think it's got the height, but I'm not sure, and I think that the building department did go out and check it, but I don't know.
Do you have any testimony that it wasn't abandoned for more than a year at any point?
Only what my clients have indicated to me, and they can, what they've indicated to me, that they've spoken to people who were around at the time. I think it might be the other way around also, that the planning department has no evidence that it was abandoned. So, I mean, it's a two-edged sword. I think that, you know, it's not that it's been in existence for 5 years and my clients are trying to gain something that they're not entitled to. This is, since they owned it, it's been more than 30 years, and they've paid taxes on it, and there's tax records to prove it. So can I say that I have evidence that it was not abandoned? I can say that I don't think anybody has evidence that it was abandoned, and I think you should give the applicant the benefit of the doubt. And I think I've said what I had to say. I think we've got the record from the past meetings. I don't know if you need anything else.
Mr. Jamarco, how far back are you going with your evidence?
I'm sorry?
How far back are you going with your evidence?
How far back have I?
Yes, are you going back to 50? Are you going back to 57? What year are you
The
going back
best I
to?
can determine, after speaking to my clients and them speaking to some old-timers that were around, that it was 49 or 50. 1949
This one never heard before.
there was a revision of the ordinance in 1949, and then there was some problem with the ordinance. It was found to be this whole book was found to be unconstitutional, and then they enacted the ordinance in 1950 or 51, and you know, we've determined as best we could. It's very difficult. We search records, we look for phone books, all of those things that make it easy for me, we couldn't find in this case. So, I mean, this is the best we can do. I can tell you that it's been there for many, many, many years, and we would like to continue it. Again, I don't know about that basement apartment. I don't know if John has any record of it, but
Do you know what the property card in the building department says as far as when COs are issued for it?
I have two documents in front of me. One is from
Tony, well,
Town Assessor, and it just notes that in May of 1979, they note 3 apartments, 3 kitchens, 3 baths. Another document I have is our property card, that would be from the building department, that in May 1st of 1978, there was an interior alteration with plumbing to a one-family dwelling. Those are the 2 documents I have, one from building, one from assessor. The assessor is just what they were noting, doesn't reflect that a building permit.
What is the original CO on the property card issued as?
We have that back in 78, that work was done, and we noted as a one-family dwelling.
that one-family dwelling notation, I don't know, you know, in those days, how they looked at it, but it was, what was it, a plumbing inspection? A plumbing?
Correct. I guess, further going on, what you would be saying is that during that time, was a zoning inspection done to verify whether there was a basement apartment or other apartments? Probably at that time, they were just looking at the work, what the permit was for.
Right.
Is there any additional documentation that would be anywhere that would indicate that it was something other than that? I mean, the record's kind of, there isn't a lot of stuff we can hang our hat on, it says,
Correct. We
other
do
than,
not
other than
have,
testimony.
Is there an application for that? Is there an application for that interior plumbing permit?
There is an application back in May of 1978.
Does the application indicate the
And
number
just
of
ref- it
dwelling
just,
units
Very
within?
general in the sense it says interior alteration. The value is about $8,000, and plumbing work was done, but it does note to a one-family dwelling.
Okay.
Now, is that uncommon? Because I know a lot of building cards will have the original CO as it was issued.
No, it's not uncommon. We normally, nowadays, we would get into the square footage, et cetera. Years ago, they would just, it would be general, something like an alteration to a one-family dwelling. But if it was a three-family, it would have been noted on the card. Again, sometimes what is there and what our records are different. That's why I noted that the assessor in May of 1979 noted 3 apartments, 3 kitchens, 3 baths.
When was this home constructed, Mr. Tramarko, originally?
I think, and again, I'm not swearing, and you didn't swear me in, but I think it was in the late 40s,
Oh, the home was built in the late 40s? you
the
think?
structure,
The structure?
yeah.
Oh. Weren't they issuing COs then? Do you know?
I don't think so.
No,
I
no
don't
COs in the
think
late
so.
40s?
I don't think, they had density
So
zoning.
predated, okay, so it predated COs. That's why you don't have a CO on the original dwelling.
I don't know.
I would surmise if they weren't.
Right.
Do you know, Mr. Bongino?
There is a note on the assessor's records, doesn't give a date, but it does say shell only. So it could have been that in the late 40s it was built as a shell. Later, the work was done, or additional work was done, according to this 1978 permit.
Did it ever get a CO?
Not for the, as the shell of the original ones, but the interior alteration work did, no. Yeah, yes, for the interior, not for, say, the shell back in, say, the 1940s.
So what was the CO issued, what was the CO issued as?
Well, the CO was just, again, for the work done in 78, not for any work done in 1940.
Oh, so it doesn't list certificate of occupancy?
Correct, there's no
Issued
right.
for anything particular?
Correct. We noted that as a one-family dwelling at that time, so if there was a question, say the applicant at that time should have noted that it's a three-family, or go for a CEU at that time for a three-family.
Could it be a one-family dwelling with 3 units?
Several times the assessor's records are different than building department records. The assessor may be taxing someone as a two-family or three-family, and the person thinks it's legal because they're being taxed for that, where building department records only show it as a one-family. That does happen. And the person goes, well, I'm being taxed for a two-family, I have a two-family, I'm being taxed for a three-family, et cetera. But our records do not show that. So you do see that contradiction at a time where people think it's valid based on they're paying for taxes,
Doesn't
not based on a CO.
Right. And they're also receiving rents.
Excuse
So
me?
They're also receiving rents. So when they say, gee, I'm being taxed on a three-family, well, and you're receiving rents for three families, so.
Correct.
You know,
And the
sort of
assessor, if
evens
someone
itself
called the
out.
assessor and said to them, I'm being taxed as a three-family, I'm sure the assessor would say, and they said, I'm a one-family, they'd say, let us in, and
Right.
if you're one family, we'll reduce your taxes.
Right, we'll change what we have written in our
Correct.
documents.
Correct.
Correct.
This is the start of the taxing of three families in 1970, of three apartments in 1979. Doesn't necessarily mean that's when the apartments were built.
Correct.
And
I
I'm looking
would
at,
agree.
you know, what John is talking about, and it does say shell, and, you know, that could have been anything. And when you apply to do plumbing work, sometimes, you know, the zoning at that time was one-family dwelling in that area, so that might be an explanation of why the card says what it says. We just don't know. I mean, again, I can't emphasize enough that my clients pay taxes on this, and they have it for, you know, the last 30, I guess, 2 years. So, that's it. I can't say any more about it.
Okay. There's no one here, so I guess we'll close the hearing.
When was the original, Mr. Tramarko, do you recollect, or do your notes indicate, do you remember when was the original hearing on this?
Do you remember when the original hearing was?
You had another hearing before this one, right, on this particular case?
It was early December.
No, we adjourned the hearing.
Oh,
I thought you had,
I don't think we ever had a full hearing on this.
No.
No. So there's no other record.
This is the only
Well, I
record
think
tonight.
no, I
you
think
know-
we had heard
did,
some
yes,
other
because
testimony about it.
you questioned me on a couple of things, Ms. Mann. Yeah, we
Did the owners come in and speak on the record?
I'm sorry?
The owners didn't come in and speak on the record,
The owners were here once. I don't know that.
that they spoke? Oh, okay.
Do you know when that hearing was? I don't.
It's in the file.
Adjourned a couple of times.
Let me have the file.
They were away.
Is there only one file, right?
Yes, ma'am. But we will not be able to know in that, looking at the file. It would just say adjourned. It wouldn't say whether it was heard and adjourned, you know?
I say November.
You could hear it? I don't know if you did it.
Case number.
16200.
Maybe he has the answer for us.
I know we started a hearing, and we adjourned it, and then there was a couple of other adjournments where there wasn't any evidence put in. I know I can find it.
Well, we started June 2nd.
I know we had a partial hearing. I can't find the date.
I don't see anything.
Well, we could check, I'll check my records, and obviously Gloria could check her records. I know there was a hearing, and obviously there are minutes, so.
Do you have something? Yes.
September.
When?
Madam Chair, I was just checking the building department records. What I have in my folder, the original meeting on June 8, 2010 was adjourned to September 14, 2010. September 14, 2010 was adjourned to October 26, 2010. The October 26th was adjourned to December 14, 2010, and then that was adjourned till tonight.
There was a hearing on one of those meetings, I know there was.
I don't have anything that states there was a hearing.
You said it was on the 14th?
I mean, I
I
have,
think we
14th
had,
December.
December 14th?
I believe we had some testimony, and it was left open and
Yes,
adjourned to a
yeah.
later date, so there is testimony. Perhaps it was that one meeting that you,
December 14th?
I have October 12th, something, let's see. Review hearing to waive condition, no. Charlie Vita was first arbitration.
If there was testimony, Madam Chair, wouldn't you have notes on that page? Don't you take notes during
I take
testimony?
notes on every,
Right.
Madam Chair could always double check at the office.
I remember that you weren't here the night we were here for 1 hour or 2 hours.
Was it on that?
Yeah. Don't you remember we called you where you were?
remember, I'm saying-
I don't know if it was on that night. Could have been. I don't know. Could have been that night.
okay, October, I do have some, wait a minute, October 26th.
And that's when you were away.
Okay, house was in San Remo Civic Association, is that it? October 26th.
Okay.
I've got December 14th.
Then it was adjourned. You said it was the Knights of Columbus, and then it was put into an apartment?
Yes.
Yeah, yes,
was on the
that's right.
26th.
It was a,
It's the 26th.
It was on the 26th.
So that would be Mary Ellen's minutes.
Mary Ellen's minutes. Okay.
Right.
but those minutes would be in later.
Yeah.
Oh, yeah, yeah.
Oh, yeah, they're in.
They're in.
There wasn't too much said on the record. You asked for an adjournment to bring in testimony.
No, but I think there was testimony.
there was some.
Yeah, there was some,
How do you know how much testimony
because I read it down.
Can I go now?
Yes,
You closed the hearing, right?
yeah, I did.
No, I don't
All right.
think we did.
No, somebody has to make a motion.
I had to make a motion to close the hearing. All in favor?
Aye.
Opposed, motion carried. In the 60s.
Good night, Irene, huh?
The end.
This one?